I would now like to invite Professor Dr. G. Mallikarjun sir to give the vote of thanks.
Thank you very much, Nabila. Good afternoon to all the special guests and presenters of this final technical session of the colloquium and other luminaries and participants. Am I audible?
Yes, sir. Yes, sir, you're audible.
And to all the luminaries and participants in this online session, my first respects are due to Professor Dr. N.R. Madhav Menon, who is at the heart of such initiatives and whom I have had the privilege and the pleasure of interacting in flesh and blood during one of such events, maybe 2 years ago. So my first respects are due to him. Then my introduction, I'm Dr. G. Mallikarjun, Professor Lloyd Law College and the Chief Coordinator of the Commonwealth Comparative Constitution and Public Law Judicial Colloquium 22 on the theme of New Asia and diverse constitutional frameworks. I may be a bit elaborate, but I would like to give a context for this vote of thanks. I would be sharing my perspectives on the theme and the sub-themes in this course as a law faculty and as a person who is madly in love with law as a discipline of study, which prompted me to leave Reserve Bank and join legal academics. I would like to take this opportunity to trigger the research instinct in the law students, teachers, and researchers. And I would seek the indulgence of Sri R. Venkatramani sir, senior advocate, whom I hold in very high esteem and idolize as a constitutional expert and public speaker, to pardon me for my errors during the first foray into speaking anything about constitution. And I have penned these thoughts during the course of this technical session. So first, with this disclaimer, I would like to start. We have come to know during the deliberations that all the 48 Asian countries have a constitution, the most comprehensive and arguably the most celebrated being the Indian Constitution. The histories of respective countries have a bearing on the form of government and governance as provided for in the Constitution. Being a part of the global community, the international law that is prevailing at the time of drafting and the codified covenants, declarations, etc. would definitely find a place in the Constitution. Because incorporating these globally accepted norms, especially those relating to rights and liberties, is a minimal expectation of citizens who are looking forward to the Constitution. Thus, international law has a definite bearing on the drawing up and shaping of the country's constitution, and this happened to be one of the themes of the sub-themes of this conference, this colloquium. Then the countries in the Asian territory are uniform only in the sense of being diverse in terms of gender, language, culture, ethnicity, and religion. And this pluralism had and has to be accommodated in some way through the provisions of the Constitution, basically to have a clarity in approach of the state towards this pluralistic society in their respective nation. So pluralism is another aspect relating to which we had a as a sub-theme in the session. Then Constitution drawn up provides a blueprint for incorporating the details of the form of the state, organs of the state, their respective jurisdictions, checks and balances, putting in place limits on their respective powers without affecting the larger public good. So now we enter into the realm of what is referred to as constitutionalism. And yesterday only I came to know that this is something which is referred to as specifically as negative constitutionalism. So going forward with the changes in the social and economic and societal values, there will be times and situations where the organs of the states have to go beyond the bounds placed by the Constitution, which trigger judicial review if provided for. The courts through judicial review decide on such transgressions and recommend changes in the legal constitutional framework to the legislature in the normal sense. So added to this, you have the influence of international law and evolution of international human rights, which continue to keep the government of the time engaged in adopting them or adapting them for the needs of the nation state, as there would be a public clamor for these best practices to be incorporated in their respective jurisdictions. So this would necessitate change, legal as well as constitutional. Then further, political pluralism plays out through differing approaches to the path to well-being as a nation. So everyone has their strategy to make everyone happy. So, but the political pluralism brings out some diversity in terms of the ways in which this end is supposed to be achieved. As such, in case of different political groups coming to power, it would like to have their agenda implemented And often this necessitates changes in the legal and sometimes even the constitutional framework. So this now brings to fore the conflict between constitutional stability and constitutional change. While emphasis on stability and immutability of the constitution would lead to dissent and protests, succumbing to every whim by changing the constitution depending upon the emerging popular demands would render the constitution unstable and ineffective. Therefore, there is a need to balance the requirement to amend the constitution and also to provide the procedural safeguards to prevent too frequent amendments. And how do you balance this is a challenge, and this happens to be one of the thematic technical sessions during this conference. Now, going forward, pushing the envelope in citizens' interest through judicial innovations and adopting concepts like constitutional morality, though it can fill the gap temporarily, this cannot be a substitute for constitutional amendment, much less legal amendments as well. So this leads us to the next aspect of constitutionalism, which again, I came to know about yesterday, which is referred to as positive constitutionalism. And I found the very term to be very paradoxical in the sense that constitutionalism itself means working within the boundaries laid down by the Constitution. Then how could you have something called positive constitutionalism, which would mean either jumping over these boundaries or blurring the boundaries for the perceived good of the masses? This becomes even difficult if the courts and the government of the time are not in alignment. While the judiciary legislative conflict is something which attracts a lot of discussion in the mind space of academia and researchers, a more important conflict with greater deleterious consequences is the legislature and executive conflict whenever there is a change in the political group which is administering the country. So constitutional stability is thus a serious hindrance in case of political pluralism and more frequent shifts in power of political groups operating within the country. So all these, and in that course, we had a technical session on constitution and constitutionalism as well. So all these extremely interlinked and fertile areas of research and publication for law faculty, young researchers and students who will be blooming into the legal profession, where the sub-themes under the overall umbrella of the theme of New Asia and diverse constitutional frameworks. So this is the context in which we have had our deliberations in this. And now I would first like to thank all the dignitaries from the legal bar, bench and academia from India and abroad for kindly consenting to be the chair, co-chair, keynote speaker and theme presenters in the 5 technical sessions. But since I am doing the honors for this vote of thanks, I want to specifically thank the special guests of this session. First, I express my deep gratitude on my personal behalf and on behalf of the Lloyd Law College in Milat to Professor Dr. Mizanur Rahman, whom I have seen very actively engaged during the law teachers workshop in terms of educating our students and the law faculty about rebellious lawyering. So he is the former chairman of the National Human Rights Commission, Bangladesh. So I thank you very much, sir, for chairing the session and sharing your valuable insights and coordinating the smooth conduct of the session. So thank you very much. Then I express my sincere thanks to our special guest another guest from overseas, Dr. Falti Hap, Director of Graduate Program, Royal University of Law and Economics, Phnom Penh, Cambodia, and who is the Regional Administrator of South Asia for being the co-chair. So it was a pleasure to have you with us, sir. I also express gratitude to Professor Dr. B.C. Nirmal, former Vice Chancellor, National University of Study and Research in Law, Ranchi, for his very thoughtful and comprehensive keynote address, bringing out the various facets of the sub-theme. Thank you very much, sir. I would also like to thank Professor Dr. Amarpal Singh, Dean, University of Law and Legal Studies, Guru Gobind Singh, Indraprastha University, for the theme presentation highlighting the issues of pluralism in relation to Constitution. And I also thank and congratulate the paper presenters for sharing their views about their respective topics of research, and some of them being controversial as well. I thank Professor Dr. Sivakumar, Senior Professor, Indian Law Institute and Administrator of the Asian Jural Conclave, for delivering the concluding address. And I would fail in my duty if I don't thank Ms. Nabila Jahar and Mr. Salman Kazmi, the greenhorn researchers from CIJER Lloyd, who just stepped into Lloyd campus in February and who have been given this onerous task. And they have done a great job in their very first endeavor as compeers of the sessions. Then I would also fail if I don't thank Professor G.P. Singh and Professor Rupesh Chandra Madhav for being the rapporteurs and ably shouldering all the responsibilities which go into making this colloquium a smooth affair. And I thank Dr. Lisa Lucas, Professor Indraprastha University and Deputy Administrator of Asian Jural Conclave for guiding me in my maiden attempt at being a chief coordinator of this prestigious event. And I thank Professor Muhammad Salim, Director, Lloyd Law College, and Professor Akhilesh Khan, Secretary General, Asian Jural Conclave, for all the support for this event. Last but not the least, I thank Shri Manohar Tairani, President, Lloyd Law College, and Secretary Milad for promoting the conduct of the Asian Jural Conclave and wholeheartedly rendering all support for hosting not only this marquee event, but many such academic activities which bring together legal jurists, academia, and researchers, thereby providing the platform and programs for students to learn from, participate in, and grow both professionally and personally. Now that I mentioned students, I would finally end with my sincere appreciation to all the student volunteers who have been toiling late and hard in spite of having just a few days for their semester examinations. This is in case of the first year students, and healing the wounds after the toil of writing their semester final examination, which is applicable to all other batches of students who have participated in terms of facilitating this program. So thank you. I request all of you to join us for the valedictory function of the Asian Jural Conclave. Thank you very much.